Do I unscrew anything or just push it?
Oh, you have to unscrew it, yeah.
I think I gotta use it because you have based on this after. Yes. Yes. And then you got it.
Yes, you have to screw it though.
Somebody turns on our house. Oh my gosh. Oh my God, just a little. And even then. Smile. So yeah. I know, right?
Are we ready?
Oh, I agree here. Too late. Oh, I think look.
Yeah. We're fine. It's gonna be fine.
Thank you.
I'm sure. Still some divorce. Like that. We will, I do, that's actually civil. This is not really. Come out.
All right, anybody ready?
One minute on page 8 again.
No.
And on run 3, Judge, we're getting that paperwork figured out.
All right, thank you.
Or we're not figured out, filled up.
Thank you. All right, who's the prosecutor on this?
She's doing something.
Okay. All right, so I don't know if you all had a chance to review that,
I did, I gave it to Jason, but
and so I'll give you all a chance to review that. Just let me know when everybody's ready. All right, the court is calling 2023 CR 3,
God bless you.
I'm sorry, 2023 CR 9393, State versus Darwin Gomez Jr. Could I have parties announced?
Megan Galloway for the state.
Mark Lifford, defense judge.
And are you Darwin Gomez?
Yes, Your Honor.
All right, you entered a plea. And according to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is opposed to your application of deferred adjudication, and there's to be restitution, if any, to the complainant. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections to the PSI report by any party?
Not from defense judge.
All right, and are there any witnesses?
No, Judge. We provided the court with a packet and then argument.
All right, and so state any objections to the court reviewing the packet?
No, no.
All right, so if I could have that back. Thank you. And let me review this.
Yes, Judge.
Right, the court has reviewed the package you wanted the court to see.
Thank you, Your Honor.
All right. And state you have no witnesses?
No, Your
All right, so the first thing I would like for you to address, and maybe you can address it through your client, it says that guilt was minimized in the PSI. What is that about?
And if you want to ask Mr. Gomez himself, you're obviously more than
do
welcome
you-
to. I was shocked when I read that because in all the conversations that I've had with him over, I mean, he took responsibility for the plea despite my urging to go to trial because he did accept responsibility to me many times. So I don't know if it was just miscommunication or, and I'm sure he can explain that to you himself, Judge.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Is there something you wish to say?
Completely regret everything that I ever did in regards to that, Your Honor. I was entirely in fear for my life, but regardless of the fact, I should have left it in God's hands and not took it into myself. And there's not a day that goes by that I don't regret what I did. I put my whole family and my wife through hardship. I never meant to do that. They all rely on me a great deal. A lot of people do. And the incident happened a month after I had just gotten married. So the biggest thing for me being fearful at that moment, I was not justified. I should have just left it in God's hands. I feel like a fool. But I'm grateful to the Lord because I've gotten closer with Christ since the incidents happened. But I feel terrible. I feel terrible about everything that had happened in that incident. And I don't ever want to do that, anything like that again. I have no firearms any longer. I don't have any intentions of going back to my lifestyle. I'm with the IBEW Local 60 Union now, ma'am, and I'm working to get my journeyman's license. And the past couple of months, I've been working on leaving San Antonio, Texas, to go to Bigfoot, Texas, to be in the countryside. And I don't plan on ever going back to doing anything near like that again. And in the instance that something does happen like that, I will happily leave it in God's hands. Whether it be me dying, me being disabled, or whatever it is. But I don't ever want my wife to be fearful to be without me or my mother and not think that I can raise my siblings or help my siblings. And it's not an excuse, Your Honor, but I want you to know that there's not a night that goes by that I don't think about the man and about what I did. I want you to know that from the bottom of my heart.
State, any questions? All right, and state, have you had a chance to review the packet? All right, and state, are you still proceeding with the plea?
Yes, sir.
All right. All right, state.
Judge, just given the evidence that was stipulated to your opposed and the offset denied.
All right, defense.
Briefly, Judge, a couple of things. Without sounding cheesy, but for the grace of God, I mean, choosing to discharge a firearm, whether he hit somebody, missed somebody, or God forbid took a life, is literally but for the grace of God. And I think the minimization is the fact that he believed, rightfully or wrongfully so, that a road rage incident was going on. And that's why that's probably after hearing him talk now, because like I said, our conversations were always like he did right now, which he was remorse for it. What I can say is this: the complainant, as you can see in the PSI, leaves it to you. He's not asking for prison. He just wants to ensure two things. One, he would like to get, I think he's out $6,300 that he lost with regards to his hospitalization and treatment. And he wants to ensure that nothing like this ever happens again with the defendant, Judge. And so starting from that, what I can tell you is this, is that in a perfect world, this never would have happened. The only positive I can say, and it sounds like a cheesy defense lawyer saying, but I've been doing this for almost 20 years, and I can say that I have, from the very first meeting with Mr. Gomez to now, I have seen not only the words of genuine remorse, but the actions to show that he's actually taking steps to change his behavior, change his actions, to be a productive member of society. When I think of, do I believe that some people deserve to go to prison? Without a doubt. And the question I've always asked myself, I've never had the honor or the privilege or the burden of sitting in your seat, but I always ask myself, is society better served with the person behind bars or the person continuing to be a productive member? In Mr. Gomez's case, he has gotten a great job, and a great job isn't a reason to keep someone out in and of itself, but he does have a good job. He's an electrical apprentice working on his way to journeyman. He's currently earning almost $5,000 a month, and he has a lot of progress within the company and within vertical moving. With regards to his views of what happened that night, the choice he made was obviously the wrong one and a dangerous one. The smart thing would have been to have called 911. Unfortunately, playing Monday morning quarterback, Judge, is not something that we had the luxury of going back and changing it. But his actions while on bond, with employment, with his family,
So sorry. So sorry.
The PSI, when it did the evaluation, did say that he is a low to moderate risk, and they confirmed that he has a very strong and a very large support network of both family, friends, and colleagues. He doesn't have a drug problem, doesn't do drugs, doesn't drink. His problem has been his response to immediate, confrontation or anger, as you've seen through his record. But I do believe, without a doubt, that one, he has taken steps to show that it's not just words, Judge, that taking steps to show that he has, one, understood how horrible and stupid what he did was, but also steps in the future of how never to be before this court, never to put someone's life in danger, never to be on this side of the criminal justice system again, Judge. If you have the courage to grant him.
Oh, well, it's not a matter of my having courage.
Sorry, Judge, and I apologize. I wasn't trying to offend you by any means. If you grant him deferred, you won't, I am confident saying that you will not be mistaken, embarrassed. He will not be before this court for an MTR or any other court for a criminal offense. He will successfully complete all conditions and terms of his deferred adjudication, and will be able to, which I've found is sometimes most helpful, is be able to pay it forward with regards to helping other people realize that, the decisions we make not only have real world immediate consequences for other people, but for society and for the families as a whole. We would humbly ask that you grant him deferred adjudication. I've explained to him that deferred subjects him to the full range of punishment, not just 10 years. And this court has a heavy hammer over his head. We just ask for the opportunity, Your Honor, humbly.
May I say something, Your Honor?
Sure.
For the past 2 years that I've been going to coming to court and going about the reschedulings and so forth, I've made it number one priority out of everything in my life to make sure that I get here no matter what it is, whether I'm in Oklahoma, I'm in Paris, Texas, or Rogers, Texas, or anywhere in Texas. And I'm very grateful that y'all have given me the opportunity to appear via Zoom and have been very lenient with me as far as appearing here to make something like this possible. But I do want to let you know that it is my number one priority to be as on time as I possibly could for any event or anything that y'all need me to do or need me to cooperate with. It's just, I want to be as cooperative as possible, and I don't ever want to look at anything like this again in my life, Your Honor. And I'm grateful to even be standing here in front of you because 2 years ago, I remember sitting in jail next to a man who stabbed his brother in the neck. And I thought that was it. That was my last opportunity to even see the outside world. And for this past 2 years, I've seen miracle after miracle after miracle. And I've met so many people that I never thought I'd meet. And seen so much that I never thought I'd seen. So I do want to let you know that I am a man of my word. And it's all I have. And I plan on staying and sticking to it no matter what.
All right. So here, we can go off the record. Here's the court's question. Let me just tell you, sometimes I think out loud. Sometimes what I'm thinking out loud, these are just thoughts. Sometimes it's hard to send somebody to prison when you see that they changed their life, but they've done something bad. And so with you, I'm balancing what you've done. I'm balancing where you are now. I'm balancing your age. I'm balancing, the complaint. I will tell you this, the complainant in this case did you a solid. Because there are some complainants who would say, I want him underneath the prison. And so what I can tell you in this is what the complainant is saying. And I'm not saying I'm gonna lean one way or not, but so the complainant says they're out of pocket. Where is this? This is the time where you need one of those sticky things to turn pages.
Your
Thank
Honor,
you.
I'm not a.
So the complainant says they're out of pocket $6,136.20. And what I can tell you is normally when people say they lost this amount from work, I'm like, I'm not allowed to legally give that. But he says he lost a week's pay. That's $1,096.16. And he says his vehicle is still impounded. I don't know if his vehicle is still impounded or not. I don't know how to check on that. But he's saying that vehicle is valued at $8,000. So if you add the approximately $6,000 plus the $1,000 out of work and the 8,000, that leaves a restitution amount
15,000.
of $15,232.36. Now, what I can tell you is I will think about this, but you probably need to speak with the state and speak with your defense attorney about this restitution amount, because it appears that's a majority of the complainant's concern.
I'll take care of it, Your Honor.
Well, no. You want to talk to your attorney about this, because what I'm telling you, this is what I've discovered in my time on the planet.
Yes, Your Honor.
Everybody says they're going to do certain things. Everybody said they're going to pay a certain amount. And then you know what ends up happening? They're on probation. They're supposed to pay a certain amount and then they don't pay it. And if there's a motion to revoke filed and it's over fees, I can't send somebody to prison
On
for
money.
not paying money if they establish that they are unable to afford it. So whenever there's restitution, especially at this amount, I usually want a majority of it paid up front. So you may want to step back and speak with your attorney and speak with the state.
Yes,
Yes,
Judge.
Your Honor.
Thank you, Judge.
And state, if you want to, just one moment, we'll go off the record. Let me just tell you. You know, it's very difficult when you have somebody who has done a 180, changed their life.
I need to come over.
He's on the right
See
path.
you.
The stipulations in this, it's sort of, you could see why
Just
things
get out.
converged and this is the way it
Yep, there-
happened. Because sometimes it's at
Okay.
night, somebody's following you, somebody's flipping you off, somebody's doing this, then everybody's driving slow. Now, if you don't have a weapon and everybody's driving slow and flipping people off, maybe you don't have this. So it's difficult.
Yeah, for sure.
They're difficult decisions. Mhm. It would be nice if I had
They were over
something
there.
that tells me, hey, if you do this, this is what's gonna happen. So we shall see.
They were there.
Anyone else who's ready? Page 5, where? Genevieve Pettis.
Okay, see you later. All right.
And are there any applications?
There's an application for probation, Your Honor.
All right, probation, there's an application. Court is calling 2025 CR 010422, State versus Genevieve Pettis. Can I have parties announced?
Brandon Lopez standing in for Rochelle Savello for Ms. Pettis.
And are you Ms. Pettis?
Yes,
Any objection to this attorney standing in?
No.
Counsel, have you received all discovery? Did you review it with Ms. Pettis?
We have, and we did, Your Honor.
Ms. Pettis, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
All right, you're gonna have to speak up.
Yes, ma'am.
And counsel, do you waive the reading of the indictment?
We waive it, Your Honor.
Court will find that the state is in compliance with discovery. State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with possession of a controlled substance, penalty group 1, 40 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Okay, you're gonna have to speak up.
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is.
Ms. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied reentry, and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's $1,000 fine. There's no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Justin Kane, and the DOEP course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
To the offenses charged, how do you plea?
No content.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea bargaining order.
All right, do you have any children?
Yes, I do.
What are their ages?
22, 21, 15.
All right, who's with the 15-year-old?
My ex-husband,
All right, and who is Justin Kane to you?
a friend of mine. Just a friend.
Then why was he with you?
I work for him. He has a business. He moves mobile homes. And we were at the location where we have our mobile homes at.
Mhm.
And I was in the wrong place at the wrong time, so,
Well, no, I mean,
but he's kind of like,
sometimes you're in the right place at the right time,
yeah.
right? So
Yeah,
how
I
often
wa-
have you been using?
No, I wasn't mine. It was his, but he put it in a pill bottle that was my name on it because he took it from a bag that I had inside the truck.
No, you said it was yours. In the police report, I'm just going by what's in the stipulation. You claimed it all as yours.
At the time I had no choice, but.
No,
it
I
was
mean,
a-
there's always a choice. You can say it's not mine.
Yeah.
Is that not a choice?
Yes,
Did somebody have a gun to your head and told you
no,
you
ma'am,
had to say this was yours?
no, ma'am.
And I don't believe this story that he's in the business of moving mobile homes and you were helping him. That sounds very odd to me. What is the name of his moving
Any
business?
transport.
It will be Kane Transport, right? Because his last name is Kane. So how long has your son been with his father?
A few years,
Why is he not with you?
because we had a real bad divorce, and at the time I was a stay-at-home mother,
Mhm.
going to school, and he had the money to take care of them, and I didn't.
Mhm. Usually they don't give custody to a parent just because they can't afford to,
Well, I
that they're the
wasn't,
ones who can afford to
I
take.
didn't have like a stability place for him, so
Why do you have a
I
stable
was
place?
staying at my mother's at the time.
Usually that's pretty stable if you're staying with your mom. So what else was going on?
It was just a real bad divorce, and me and him, he just had money and I didn't. He just.
All
took
right, so
them.
you want to talk to me about this drug issue? Because I'm telling you right now, if you're telling me you don't have a drug issue, you know what I'm gonna do? I'm gonna put you on the IVR hotline. And I'm gonna send you out to in the world on the IVR hotline. And the first time you test positive, a motion to revoke is gonna be filed. And I'm gonna see where you said that you didn't have a drug problem.
I used to have one a
No.
while back, but not now. Like, I've changed my life. Like, I don't use anymore.
Let me just tell you, people usually do not use when they're at the jail unless they're making drugs at the jail, which sometimes they do. But there's this methamphetamine. So how long have you been using meth?
5 years,
And how often?
once in a while,
What does once in a while mean?
occasionally,
What does occasionally mean? I'm not with you.
this depends. I don't use every day.
All right. So how often are you using?
Weekend,
So is this every weekend?
no,
Then how often is it?
whenever I get a chance to get away and use.
All right. So you don't have any children. When's the last time you were employed?
It's been a minute.
All right. So it's been a minute since you've been employed. You don't have your child with you. You use when you can get away to use. If you're not employed and you don't have a child, it seems to the court that you get away a lot to use. So how often have you been using?
It's just occasionally on the weekends.
And is this every weekend? Is this
No.
every other weekend? How
I
often
could
is it?
say maybe like twice a month. I go out and just hang out with a couple of friends.
Mhm. I don't believe you because of the amount of drugs you've had and the fact that is with this Justin Kane person. And I'm sure if I were able to find him on the street and do a UA of him, he's going to be positive for meth.
That's on him.
All right, so I'm going to make it on you because this is what we're going to do. Probation on this case. As previously stated, I'm finding there's sufficient evidence to find you guilty. I'm going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's $1,000 fine. There's going to be 200 hours of community service restitution. 100 hours will be deemed satisfied upon completion of parenting classes. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. No residing in a household with minors. No unsupervised contact with minors. IVR hotline with testing at least every 2 weeks. Regular reporting by Zoom or in person. In custody, the following: TAP evaluation and a referral to felony drug court. There's to be no contact with Justin Kane, Cain. Field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Anyone else ready?
Yes.
All right. And let me see what page they're on. All right, Javier Baldares. Baldares, thank you. All right, are there any applications?
There's application for straight probation, Your Honor.
All right, probation, this is an application. Court is calling 2025 CR 010372, State versus Javier Jorge Balderas. Can I have parties announce?
Brandon Lopez for Mr. Balderas.
And are you Mr. Balderas? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor, and we did review it.
Court will find that the state is in compliance with discovery. Mr. Balderas, did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading?
We waive reading, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will be leaving the enhancement allegation.
No objection, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
You're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is, Your Honor.
Mr. Balderas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And I'm sorry, counsel, are you listed as the attorney of record?
And Your Honor, you're right. I am here on behalf of Rochelle Savella representing.
Any objections to this attorney standing in?
No.
Right. Next, I want to, did you review the plea bargain page with your attorney? Did you understand it?
Mhm.
You need to say yes or no.
Yes, ma'am.
Okay.
Sorry.
According to the plea, punishment is to be assessed at 8 years in the prison. There's $1,000 fine. State recommends to community supervision. They're taking in consideration 2025 CR 010373. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours community service restitution, and no firearms in the DOEP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
To the offenses charged, how do you plea?
No contest.
State, any evidence?
Yes, Your Honor, state offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We ask the court follow the plea bargain, Your Honor.
All right. Do you want to spend the rest of your life in prison?
No, ma'am.
Then why are you doing this?
I'm gonna tell you what happened.
Well, I mean, I'll listen to you, but here's the thing. If you're gonna say something that's outside the stipulations, I can only go with what's in the
No,
stipulation.
no, I'm gonna tell you why I had the weapon.
Okay, sure.
Okay, the reason why I had the weapon was, a year ago this month, I was shot outside my house by a random person. They still don't know who it was. Okay, and, I have a 15-year-old son that I got sole custody of. His mom died 3 years ago. I have an 86-year-old mom that's there too. I take care of them. And basically I was in fear for my life, because I've been living there 35 years. I never had no problems like that. There's a police report. I drove myself to the hospital. I got a bullet hole in my leg. And
So while you're driving around in a vehicle that has no inside panels and that's been stripped on the inside,
I'm sorry?
according to the stipulations, it says,
Oh, I understand I know. Okay, that they had no inside panels. It was because when they picked me up, okay, when they picked me up, that car, we're putting speakers into the car, and we had the panels off.
Mhm.
That's why, and police officers, the 2 officers had come there before they even came and picked me up on the blue warrant, and they talked to us, so they knew what we were doing. They asked us. That's why it was open like that, because, and we're putting speakers into the car.
and was that your vehicle?
No, it's my mom's, actually.
All right, so in here, it says that you told them it wasn't your vehicle and you were you really didn't give an explanation as to why everything was missing from inside the vehicle.
Well, there was nothing missing. Everything was, all the panels were in the back of the trunk.
They said the radio,
Yeah, it was, we were
the
putting the radio,
speaker,
speakers and
the
radio.
door panel, and the lining of the vehicle was taken apart.
Well, because like I said, we were putting, you can check to see it belonged to my mom. It was my mom's vehicle, and they actually let me, let it go, let them take it back to her. Somebody, that was there with me. I gave them the keys and they drove it to her house. But I had the weapon. Yes, ma'am, I did. I'm not gonna say I didn't have, I'm not gonna lie to you.
And then this contraband, because I'm sure your mom is not driving around with drugs in her vehicle.
No, ma'am, no, ma'am, no.
So-
No, I had that too, and I'm not gonna lie, because like I said, what happened, I've never been shot before, and it kind of messed me up. No, it didn't kind of mess me up, it messed me up. And when I had.
Well,
when I
no,
came-
it says here, from my training and experience, I knew this to be methamphetamines. Suspect, that's you, quickly stated the narcotics was not his because he borrowed the pants from an unknown person.
I don't know where they got that, because I told them it was mine. He took it out of my pocket, so I'm not gonna lie. And I told him the gun was mine too. I admitted to all the stuff.
All right. Anything you wish to say?
Nothing further, Your Honor.
When's the last time you have employment?
I'm actually, what I was doing was selling hot dog carts.
Mhm.
I'm 62 years old. I was getting ready to retire and stuff, but I've been selling hot dog carts, and I had a business. It was a transmission business right there between Eisenhower and
And what happened to the blue warrant? What was the outcome?
I'm discharged. They're waiting to see what happens. I've got 24 years on it, on a 25-year sentence. And I've got like 600 something days of back time and only have like 500 something days left on it. So I should have already discharged like 100 something days ago.
All right, here's the thing. You have a choice, and this is your choice.
Okay,
One, I can follow your agreement, give you probation, or if you all want to renegotiate, I can sentence you to 2 years.
I'll take the probation.
All right, the court is going to sentence you to 8 years, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. Take in consideration 2025 CR 010373. And how old is your child?
15. He's been with me for 11 years.
And where's the mother? Who else?
Mother died 3 years ago in July.
And who lives in the household?
My mom and my son.
All right. There's to be no unsupervised contact with minors.
I can't be around my son.
No, you can.
Okay,
Your mom just has to be there.
okay, that's fine.
There's gonna be 200 hours of community service restitution. I'm gonna order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. 30 sober meetings in 30 days. And the DOEP course. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank
You're
you.
welcome.
Thank you, Judge.
You're welcome. All right, anyone else ready? Oops, sorry. It's okay. Yes. Joe Anthony Thomas. Are there any applications?
No.
All right, the court is calling 2025 CR 009050. State versus Joe Anthony Thomas. Could I have parties announced?
David McLean for the defense.
And are you Mr. Thomas?
ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
That's our understanding, Judge. We have no objection.
And are you proceeding on both counts?
Yes.
All right, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In count one, you're charged with aggravated assault with a deadly weapon. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. Those both are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas to counts one and counts two, you will be deported, denied naturalization, and not be allowed to re-enter. Did you understand?
Yes, ma'am.
Court will find that defendant has no All right, did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on counts one and counts two. Punishment in each count is to be assessed at 8 years in the prison. There's a $2,000 fine. In count one, there's an affirmative finding of deadly weapon. There are no applications. This will run concurrently with 2022 CR 3270 and 2023 CR 11355. Did you understand that to be your plea?
Yes, ma'am.
Defense?
That's our plea, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there many such motions?
No, Your Honor.
Then to count one, how do you plea?
Contest.
Count two, how do you plea?
Contest.
State any evidence to support the defendant's plea.
State's
Your Honor, I reviewed that with my client. We have no objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. Thank you. All right. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of counts 1 and 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we asked the court to follow the plea bargain. We've analyzed this case long and hard along with the state's counsel. And we're hoping that we can try to get this case disposed of. We just asked the court to follow the plea bargain.
All right, then, as previously stated, the court is finding you guilty of counts 1 and counts 2. The court will sentence you to 8 years in count 1. There's an affirmative finding of deadly weapon in count 1. This run in count 2. Court will sentence you to years. 11355, and there's a $2,000 fine. Is there anything else from either side with regards to sentencing?
Speaker.
Your Honor, I wanted to clarify the cases that, did you say those were being taken into consideration? Or concurrent?
I'm sorry, concurrent with.
Thank you, Judge. Yeah, I
Thank
believe
you.
that
Thank
was-
you for the correction.
No, I believe that was what the agreement was.
All right, and so for the record, this cause number 2025 CR 009052 will run concurrently with 2020 CR 3270 and 2023 CR 11355, and counts 1 and counts 2 will run concurrently.
Thank you, Judge.
Just one moment. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're proceeding with 2022 CR 3270. And 2023 CR 11355. Did you review the document in 2023 CR 11355 entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Anthony Thomas who was placed on deferred adjudication in 2023 CR 11355 for the office on unlawful possession of a firearm by a felon on April 2nd, 2024 for a term of 5 years? Is that you? And in cause number 2022 CR 3270, are you the same Joe Anthony Thomas who's placed on community supervision on April 28, 2022 for a term of 6 years for the offense of possession of a firearm by a felon? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the 18th day of April 2025 in Bexar County, Texas. The defendant, Joe Anthony Leopoldo Thomas, committed the offense of assault in violation of condition number 1.
And is that the same allegations in both motions?
It is, Your Honor.
Then in each motion, how do you plead to that allegation? True or not true?
True.
All right. And cause number 2023 CR 11355, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, ma'am.
Court will find violation of condition number one true and cause number 2022 CR 3270. Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one? Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor, it's for to grant the state's motion to revoke the defendant and sentence him to 8 years in prison.
That's our understanding, Your Honor.
All right, Mr. Thomas, what I can tell you in the motion to enter adjudication of guilt, it appears to the court that you have learned nothing. So, in cause number 2023 CR 11355, the court is going to grant the motion, find you guilty, revoke. The court is going to sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with 2025 CR 09050. There should be no contact with the following persons: Christopher Michael Talamontes, Vincent Bernard Alanis, Joshua Patrick Helton, Rings of Fire Tattoo, and in cause number 2022 CR. Oh, and I'm sorry, this is also to run concurrent with 2022 CR 3270. And cause number 2022 CR 3270, the court is going to revoke. The court will sentence you to 6 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CR 009050 and 2023 CR 11355. And there's to be no residing with minors and no unsupervised contact with minors. In each of those cause numbers, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? All right, in each of the cause numbers, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication or community supervision. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, yes.
Just briefly, just for my client's verification, and I know the court's probably already done this, but in each of those cases that we heard here today, my client wants to ensure that he's getting credit for the time that he's already served.
Yeah.
And at any time when he's running concurrent.
Yes.
Thank you very much, Your Honor.
All right, thank you.
Excuse, Your Honor.
Yes.
Thank you very much.
Ms. Hopkins.
All right, Mr. Martinez has been sitting there. Are you all ready on his case? All right, thank you.
Have a seat, Miss.
All right, as soon as I have you guys' paperwork, I'll take it up. You're welcome.
Were you off though?
Never know.
Yeah, she's not ready. Okay, so we're gonna do. You know what, I know what I told you. Go ahead and do that. Judge, are you ready?
No.
No, I was wrong. Nothing. Okay. I'm not sure. You know what I mean? It's kind of like that's versus no. Okay.
I do.
Could I have that last file back, please? Yes. Thank you.
Yeah. Just see.
All right, I'm ready whenever you all are ready.
Judge, can we approach?
Yes.
Just off the record, I wanted to get your opinion on something.
Okay.
We've been conferring with the state. I've conferred with her for about an hour plus, hour and a half. It is my opinion that she needs a little more of a mental health, and I don't mean the mental health evaluation. I think the competency is my question. She's asking the same question over and over, and it's
So are you
mainly
saying
because
she's not competent?
I don't think she's understanding what's going on. And then I have spurts of, I think, lucidity where I think she's getting it. And now I don't think she understands. However, I do understand that the mental health component is one of the requirements where they want or possibly agreeing to plea, but I just don't feel, because the
Now,
question
here's
keeps
the
coming
thing.
up.
If you don't think she's competent, then we'll schedule her for a competency evaluation.
So what I would request is that I really don't know how to approach this, Judge. Maybe if we start the proceeding and you feel like, because I know the court can also, I don't want to be paranoid. So I don't know. I don't want to put her at more time because she has been there 6 weeks, I believe.
All right, so here's the thing. If you believe that she's not competent, then we can't proceed. So you're on community supervision, a form of probation. Do you understand?
Yeah.
All right, so what you're on probation for is a third-degree felony. So you're on probation for obstruction or retaliation as a third-degree felony. Do you understand? All right, the range of punishment for that is anywhere from 2 to 10 years. And the reason why it's from 2 to 10 years is because you're on deferred adjudication. Do you understand? All right, so if you were to enter into a plea of true to any of the allegations that are in the motion to revoke, then I could find it true. Do you understand? And if I find it true, it doesn't matter if you have worked out an agreement with your counsel in the state, I could still sentence you to 10 years. Do you understand? Okay, all right, just have a seat. We're gonna get with you in just a moment. All right, just have a seat.
Judge.
Thank you. All right, who else is ready?
Judge, I have.
Are you off docket?
Off docket.
Oh, then you're at the end.
Oh, sorry.
Said Naomi Alba, page 4 went down.
Oh, just one. Yeah, yes, that is. Yes.
Naomi Alba, page 4 went down.
Naomi Alba. All right, hello.
Hello.
What's happening with this case?
We're on a plea deadline today. I'm requesting a 1-week extension of that plea deadline because of the fact, 2 reasons. Number one, she is on parole right now and she doesn't have her parole paperwork. It was lost in one of the moves. But I want to be able to contact her pre-revocation officer. And secondly, because of some of the things that she told me today relating to communications with a particular detention officer, I did not see in any of the list of discovery items anything related to that officer. I'm trying to find out if there actually exists. I've talked to the state about this, but I'm trying to find out if there's any other detention officer that might have body camera of an interaction when she was first taken to the South Tower.
All right, Ms. Ferguson, recall this for Thursday. Mm-hmm. All right,
Thank you,
Judge.
you're welcome. Who's next?
It's, Mr. Darwin.
All right, so let me ask you this. When are y'all ready on Mr. Martinez thing? He's been sitting here all day.
Yeah.
All right, on Darwin, what is happening with Darwin?
I've confirmed with the state judge and my client. Don't want to overpromise and underdeliver. And I don't know how much time the court would consider. He thinks he can come up with at least about $10,000 in about 6 weeks, 8 weeks. I don't know.
Oh, just one moment.
Yes, Judge. And we initialed him, Judge.
Okay.
Sorry, that was my fault.
No
Bad.
problem.
I hear your notes, Judge.
Thank you. All right, state on. Please.
Yes. Judge.
All right, so on this case, we're gonna recall it. Norma, I need a reset date in 6 weeks. All right, so you're gonna be back on November 17th. At that time, you need to come state, do y'all accept cashier's check or money orders for restitution? All right, you're gonna come back with the cashier's check or either a money order. Who does he need to make it out to, the complainant? All right, Ms. Galloway will give you the complainant's name and you need to have that made out to the complainant. And then after that, the court will make a decision on your application.
Yes, Your Honor.
All right, once you sign the reset form, you're excused.
Judge.
Thank you, Your Honor. God bless you.
Oh, thank you. God bless you too. You never really know 100%. You just have to go with your own life experiences. And sometimes it's based upon what they're telling you and what's in the reports. All right, next one. Thank you. Hello.
Commissioner Ramos, you need to speak up nice and clear, because this judge needs to hear a verbal response and that lady needs to hear it too, okay? Nice and clear.
Thank you. And thank you for your patience.
Oh, Judge, what? You miss out on being in your court all day,
Ah, you're so awesome.
plus your personnel?
All right, the court is calling 2025 CR 007621 State versus Jesse Ramos. Can I have parties announced?
Carlos Martinez for the defendant, Your Honor.
Are you Mr. Ramos?
Yes, ma'am.
Did you review all of the discovery with your client?
Yes, Your Honor.
And have you received all discovery?
Yes, I have, Your Honor.
Court will find that state is in compliance with discovery. Mr. Ramos, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, peace officer, or judge as a second-degree felony? Range punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is. He was and is.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision. There's to be restitution upfront of $5,000 to the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, it is, Your Honor.
State?
It is, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you waive, unfold your arms. By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand that was recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
No consent.
State, any evidence?
It offers states.
And defense has no objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, it's my understanding, he has to pay restitution up front. Has that already been done?
It has, Your Honor. There
Oh.
was a holdup this week.
That was the holdup. All right. Anything you want to say?
No,
I mean, well, you should say something because I don't have to follow this agreement. So why are you doing this?
doing what? You're right.
Do you not know why you're here?
Yes, Your Honor.
So 1, why are you smoking marijuana on private property? Why don't you leave private property when people tell you to leave and it's not your private property? Why would your family give you the okay for this? Why would some random girlfriend who says she's your girlfriend say leave him alone, and then she jumps in it trying to fight the police, and then your mom comes up and is sort of like okaying that? Why? That's my why.
The venue owner had mistaken me for another person that wasn't even supposed to be at the wedding or invited. He had just showed up like a family friend.
So this,
I wasn't on the property. I was walking like back to the property, and the cop and the venue owner had mistaken me for him and told me not to come back.
no, it says, I observed the listed suspect later identified as Jesse Ramos, that's you, right? Walking in the immediate area with a blunt rolled and tucked behind his ear, and could smell the odor of intoxicants emanating from him. That's you.
Yeah, but I wasn't smoking. I didn't have nothing on me when they got me.
They said you had a blunt rolled up and tucked behind your ear.
I didn't. I just had, I probably smelled like it, but I didn't have nothing on me.
I'm reading with this. This is what you stipulated to. And then, so there's an altercation where the police are saying, nope, you're not free to leave. They're detaining you. Then some female comes up and they only identified her as your girlfriend, begins to interfere with the detention by pushing herself between officers and attempting to move their hands off of you. So who is this girlfriend?
She was a friend. I don't know why she called herself my girlfriend. Or
Uh,
did that to get in the mix.
Oh, so she did that to get in the mix
I don't know why she did that or not, but
because you told her she was your girlfriend?
she was not my girl. I don't know why she got in though. There was no need to do that.
And then it says a large crowd of family began to approach from our rear area.
That was to try to break everything up. Dude.
No, why? There's no need for them to break everything up. They were detaining you. And then the officer says that you put him in a headlock. And then it says a crowd began to wedge themselves between the officer and you. They ordered the crowd to disperse and told them that you were being detained temporarily and not free to leave. Another female, later identified as your mother, Ashley Marie Perez, is that your mom?
Yes, ma'am.
All right, began to shout back that she would take him home, to which I responded, Ramos was not free to leave. Ultimately, the crowd of individuals guided Ramos beyond my initial ability to pursue. So that's what I'm talking about. Why are you doing this? And how old are you?
I just turned 21 in July.
You just turned 21 and your mom is allowing you to smoke marijuana and have blunts. How far did you go in school?
So sophomore year.
Sophomore of high school?
Yes, ma'am.
And your mom is allowing you to smoke marijuana, be out here at this hour,
That was her wedding night.
and your mom is allowing you to be out here at this hour smoking marijuana and allowing you not to graduate from high school. That's what's wrong with society today. Part of what's wrong with it. Everybody's trying to be somebody's friend instead of being a parent. Why would your mom allow you to be smoking marijuana? Are you going to say everybody at your mom's wedding venue was smoking marijuana? Your mom, I think that's your mom. She's shaking your head and said nobody was doing marijuana at her venue, I guess, except for you.
Off the property, yes, ma'am.
So your mom is allowing you to smoke marijuana. Your mom allowed you to drop out of high school at 10th grade. So do you have a full-time job?
As of right now, yes, ma'am.
Did you have a full-time job then?
In high school, I was working, yes, ma'am. That's the reason why I stopped going.
I don't know why parents are allowing this. So where do you work?
Right now, Taco Cabana, and then I work in have a spot in the company. It's out of town.
What is that?
It's my cousin's. He has a LLCs and businesses.
I don't know what that is, Council.
I think it is putting those signs for the weekends and then picking them up by Sunday afternoon or late afternoon.
Mhm.
We
Something
like
like
do
that.
remodeling.
And plus a remodel and stuff.
So have you learned something from this?
Yes, ma'am.
What have you learned?
Not to ever do this again. Put my hands on an officer, get in an altercation.
And let's see how much you've learned. When I drug test you today, what are the results going to be? Because that'll show me if you learned something.
From probably dirty from like the past month because it takes a while to get out of your system.
No, it's this happened on or about November 16, 2024. And if you learned something from that night, you still wouldn't be doing drugs. So are you telling me this is some new form of marijuana that stays in your system like close to a year?
No, he meant to say that he probably smoked like a month ago.
Yeah. So he didn't learn anything from this because a month ago, we're in October. So a month ago, it to put us in September of 2025. So you have learned nothing. Who do you live with?
My tia.
All right. So what, your mom put you out or did your mom's new husband put you out?
No, ma'am. I moved over there because it's closer towards the city. She stays more like far west side, Helotes area.
I don't know if he's going to do well on probation. And let me just tell you why. I don't think he's learned anything from that night. He's still doing marijuana. I'm going to follow your agreement. I'm just telling you the tea leaves are saying that he's not going to do well. And his mom is not helping because everybody wants to be everybody's best friend. I don't know what happened. I don't know what's happening at his tia's house. I don't know. Is your tia allowing you to do drugs at her house?
No,
Then where are you doing drugs?
2.5 free time.
And where would this be?
3 hours during the day I have to myself when I get away from people.
Yeah, but where are you when you're doing drugs?
Outside.
See, he needs structure. He doesn't have it. I can't give him structure other than tightening up his conditions of probation, but I don't know if he's going to do well on probation.
We've discussed that, Judge, in my office and the days that we've been in court, and he assures us that he's gonna stay away from marijuana, because I told him you can't be doing marijuana or anything
I
like
can't
that.
mess up. Yeah.
I made that abundantly clear, Judge.
Oh, I'm so sorry. I don't have his, this is the wrong, trial court certification. Okay. So I need the other one from over there.
Okay. We'll get it, Judge.
Okay. All right. Oh, you can go ahead and get it. Thank you. All right, probation. This is what I'm gonna do. Sentence him to 8 years in the prison, suspended and probated for 8 years. There's a $2,000 fine. That will be probated. Do you have any children?
No, ma'am.
Okay, that's a good thing. You're not ready. There's going to be regular reporting by Zoom or in person, regular random UAs, tests for levels, field visits 1 time per month until further notice. There's to be no contact with Ethan Durand. 200 hours of community service restitution. Those hours will be deemed satisfied if he obtains his GED or some type of trade school certification. The court will note that the restitution has been paid in full.
Judge, there was,
Oh, there's some more restitution.
well, we left it that if there was less, it was okay, and but if it was, happened to be more, that the victim would document with probation,
Mhm.
and my client is willing to agree that if there was something else that he could pay it, Judge.
All right. Can I have a restitution hearing in 30 days, please?
November 10th.
All right, state,
Yes, Judge.
by November 10th, let us know if there's any restitution.
And the attorney that's out, ADA, she was working on that, but she wasn't in court today to give us a response. She might already have that answer.
Okay.
But she was calling in from court the last time we were in court last Thursday.
Okay. Probation, is there anything else? Thank you. Proof of employment within 35 days. No employment as a home health care provider or with minors. And there should be no residing with minors. Is there anything else you need to be successful?
No, Judge, thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I hope you do well on probation, because if you do not, you're looking at potentially 8 years in the prison. Do you understand?
Yes, ma'am.
So if you're trying to make a decision, is this something I should do or not? If it's going to result in you having a motion to revoke, don't do it. If you think, oh, well, maybe, or maybe they'll catch me, maybe they won't catch me doing this, don't do it. Because your attorney will tell you, I take no pleasure in sending anyone to prison, but if it's warranted, I will. You understand?
Yes, ma'am.
Now, I don't know what's happening with your mom. I don't know why your mom allowed you to drop out at 10th grade. I don't know why your mom allows you to smoke marijuana at her wedding. I don't know what's going on in your household, but obviously you're going to have to be your best friend. And as your own best friend, you're supposed to want what's best for you. And what's best for you is to complete this probation and stop using marijuana because you don't know what's in it. And it's going to result in your being revoked. You understand?
Yes, ma'am.
All right, good luck to you. Thanks,
That'd
Kat.
be excuse you.
Yes, good seeing you.
Yes, same here.
Thank you.
You're welcome.
Yeah.
But yeah, competency, you can't move forward when somebody is deemed to be incompetent. They don't understand what's going on. And she's going to have to address that with her client. So we're going to have someone to come down and hopefully address that. Hello, hi. You're just here for the entire day with us.
Yes, Judge, I missed you that much. gonna start charging me rent.
Court is calling 2025 CR 004501 State versus Ruben Renteria Jr. Could I have parties announced?
Mark lift fence.
And are you Ruben Renteria?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Renteria, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
I have, yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unlawfully carrying a weapon in prohibited places as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication if any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was.
Mr. Renteria, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Did you understand if you're not a U.S. citizen, you will be deported, denied re-entry, and not allowed to naturalize?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. This is run concurrently with 2024 CR 2438. And there's to be restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is it?
Yes,
the
Your
plea?
Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours community service restitution, substance abuse treatment facility, no contact with Celeste Blanco Ponce, MRT, and no firearms. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor. State offers States Exhibit 1 and all attachments.
No objections, Your Honor.
Right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I do understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, I mean, he's had a rough patch with making some really bad decisions. What I will say is this judge is on these last couple of cases, working through it. The best thing I can say for him is that he, I believe, is finally, later than I would have liked, but pulled his head out of his rear. He is working on a barber license and legitimate lawful career paths so that he can continue in a fruitful working path and not continue to make the same mistakes. This is the same person that we talked about earlier with regards to MTR. We would like to see if drug court is an option. I do believe that has been his biggest hindrance is his reliance upon marijuana. And without that being, quite frankly, addressed, we're going to be back here again. And so he is serious and proactive. I've gone over to him. You know, I've talked with people where they're like, oh, I don't want the hard thing. I want, just be done with it. He wants to successfully complete and be productive and put us all behind him, Judge.
All right, so the referral to felony drug court is going to be done in custody. And the TAP evaluation, if there's an updated TAP evaluation that's needed, it'll be done in custody.
Tomorrow, with felony drug court at 10 a.m. Just want to make the court aware.
Mhm.
We already have that.
All right. So my understanding is that you have an appointment with felony drug court at 10 a.m.
It's my understanding, Judge.
tomorrow. If you miss that appointment, that's going to be a violation of your probation because I'm going to set it as a condition. If if felony drug court does not accept you, you're going to come right back here and we're going to do an updated TAP evaluation in custody. Do you understand?
Yes, ma'am.
All right, there's regular reporting by Zoom or in person, regular random UAs. And you're to report to felony drug court on October 7th, 2025 at 10 a.m. Probation, if he does not arrive, a motion to revoke will be filed. Oh, I'm sorry, you may be, not excused yet. If not accepted in felony drug court, then you're to come back to the one at 87th and you're going to be taken into custody for a TAP evaluation in custody.
Yes, Your Honor.
Yes, sir.
There should be 200 hours of community service restitution. No contact with Celeste, Celeste, Blanco, Ponce, Ponce. There should be field visits one time per month until further notice. Probation, is there anything else? Thank you. Proof of, all right, it's 8 years deferred. Proof of employment within 30 days, no employment as a home health care provider or with minors. All right, is there anything else you need from the court in order to be successful?
I don't think so, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Are you all proceeding with he had already entered a plea of true. In 2024 CR 2438, the defendant had entered a plea of true to violation of condition number 1. The court is finding violation of condition number 1 true. The court will deny the motion, alter and amend conditions for this to run concurrently with 2025 CR 004501. Defendant is to report to felony drug court on October 7th, 2025 at 10 a.m. for assessment. If not accepted by felony drug court, then TAP evaluation in custody, follow all recommendations. Probation, is there anything else? All right, good luck to you.
Thank you, Judge.
Thank you. And let me see.
Maybe excuse Your Honor.
Yes, unless you want to stay here.
As much as I've enjoyed it, Judge. I'm picking my son up.
All right. All right, who else? All right, are they ready on her client?
I haven't had any word yet, Judge, on her client. I think no.
All right, just give me a moment. Let me put this in Odyssey.
Briefly,
Yes.
when was the dismissal tendered this morning for the drug case?
No.
No, okay, perfect. I'm gonna fill that out.
All right, thank you. All right, so why do I have a motion to request for pre-sentence investigation? I can't request a pre-sentence investigation until there's a plea that has been entered.
Well, the plea is scheduled for the 14th.
Until the plea is done, I cannot do a pre-sentence investigation report or request one because there is no plea.
Handle that. I'll see
Okay,
you on the 14th.
all right, see you then.
But you'll hear that at the sentence.
Yes.
Okay.
Here's this. And who are you here for? What are you here for?
Judge, I have Corbin Samansky. He is set on the 23rd on your docket. On October 23rd.
All right, do you have a case number?
Yes, ma'am. 2025 CR 006420.
Yes.
I would love to have a 2-week extension. I'm going to be out of state on the 23rd.
When are you returning?
I'm returning the 5th.
All right, Norma, can you put this on November 6th?
November 6th, Judge.
Yes.
Thank you very much. You're going to give me a set. Okay. All right. Thanks very much.
And are you gonna contact your client?
Yes, Judge. I'll take care of that.
All right, thank you.
Thanks, Judge. I'll see you on the 6th.
Thank you.
Nathan?
Yes. All right, so we just have the one case remaining? Where are the attorneys for her? All right, thank you. But yeah, so like we discussed earlier, if somebody is deemed to be incompetent, you can't move forward. There's nothing you can do. And once a defense counsel files a motion suggesting incompetency, you can't move forward until a judge finds that that person is competent. Oh, you're in limbo until that's done. And we have a shortage of doctors to determine people's competency. There's a shortage at the state hospital. Normally, if you have somebody who's charged with a violent offense, it's automatic if they're incompetent, they're supposed to go to an inpatient facility. But now, because there's such a shortage at the state hospital and everywhere else, sometimes they try to see if they can regain competency at the jail. So there's a long, long wait. And there's nothing we can do until there's more funding for it. Yes.
Hey, Judge.
Mhm.
So yes, we conferred,
Christine McDonald.
Christine McDonald, she's so sweet.
Yes.
Thank you for coming. So Judge, we are going to move forward with the motion for the mental competency examination. I did have a moment to speak with Counselor McDonald and brought to my attention some options, but we will get to that if we need it, maybe like I think you mentioned a new trial or something.
Judge.
That's the concern, I think.
All right, let me see that file. I'm sorry, what is
You
your?
don't have I have this, Judge, I'm sorry. That was not true.
Oh, no,
I
no,
have
no.
I have a file for.
Do you have the file on Jenna Lay Rodriguez? Thank you. So Miss Rodriguez, if you'll come down. And I see where previously there was a competency done. I don't know if it was ever completed, but that was from 2024. So Miss Rodriguez,
Yes.
everybody, I just wants to make sure, and I want to make sure that you understand the consequences of doing certain things. So I just want to make sure that you understand everything, and your attorney wants to make sure that you understand if you were to plead true, what were the consequences? Because sometimes there's an issue and your attorney just wants to make sure that the communications are open and that you understand everything that's going on. So we're going to bring in, I say we, but your attorney is going to bring in someone else, a doctor, and that doctor will interview you, and that doctor will be able to tell your attorney whether or not you all are communicating where you can understand each other, not be two ships passing. You understand?
Yes.
Okay, and I'm going to try to get that done as soon as possible. It's been taking a little bit of time, but I will put in the system that I'm requesting that it be expedited. So we're going to try to get it done as quickly as possible, okay? But I really think it's for the best.
Judge, if I could on the record,
Oh, we'll go on the record.
mention,
Just 1 second. We're on the record in 2024 CR 008-524, State versus Jenna Lay Rodriguez, and for the defense.
Teresa Max Vasquez.
All right. And Ms. Rodriguez is standing before me, and also Attorney Christine McDonald is here. The court sees where a competency evaluation was previously completed or at least requested on October 1st, 2024. And the evaluation report was received by the court on December 16th, 2024. And defense believes that an updated competency evaluation needs to be completed before there's a continuation of any motion to revoke. Is that correct, defense?
That's correct, Judge.
Okay. And what the court will do, the court will order that a competency evaluation be completed, and I'll order it expedited.
Yes, thank you, Judge. I just want to put on the record, my client has asked several times for a bond. I did confirm with her that I will submit the motion for a bond and the process and the procedure that is required to go through for obtaining a bond. And what happens in the interim between custody, getting evaluated, and the request for a bond.
Mhm.
I did speak with the state. They have some research to do on her history to see if they would entertain a approach as silent or agreement on a bond, but that is where we are today. So I will submit that today, Judge, just to
Right.
inform. the court.
Norma, if you can do let them know I want an expedited competency. And then if we could recall this, if you can give me a 1-month reset. And what I can tell you, Ms. Rodriguez, that 1-month reset is just to make sure the competency evaluation has been completed. If your attorney wants to come back sooner on getting a bond, then the court can always hear things sooner and be brought back sooner. Do you understand? Okay. Oh, all right.
Do you understand?
All right. Do you have any questions about anything?
No.
All right. Thank you so much for your patience.
Thank you, Judge.
You're welcome.
That's all I have, Judge. Maybe.
Yes.
Was that all you needed? Was that on?
Yes. And then let me just see, because I know we have that other matter to discuss with mental health court.
Yes, I think that's on Zoom.
Yes. So I'm going to see if they're going to Zoom in here, if there's another Zoom link. Do we have anyone else on the docket? All right. If you want to call Mr. Bonk and let him know his client isn't here. All right. Could I see the files on Brandon Muscal, please? And then we'll be back tomorrow at 9.
I don't, did you by any chance give me balls?